So I'm particularly going to focus from an in-house counsel perspective where our clients are actually the management upstairs. Just a quick caveat, I was unable to attend yesterday, so I am very mindful I may be stepping on other people's toes from a presentation perspective. So when I glaze over those, I do apologise if I offend anybody. So just picking up from my previous speaker, from a cost and time perspective, I would say certainly there's a question about you get what you pay for, but in my experience, international arbitration absolutely is not the cheaper alternative. I'm not saying that is a bad thing, but it certainly in my experience costs considerably more than a litigation through the local system. However, what it does give you is more certainty of forecasting costs. And from a corporation perspective, that's often as important as the actual number that you're going to spend. When it comes to a time perspective, it really, and I've purposely chosen the wording of initial time period, because I've had situations where the enforcement of an award, and I know that was touched on yesterday, can take as long as the substantive hearing itself. So from an initial time perspective, it may well be quicker, but you then got to factor in actually getting the enforcement through. That may be a good thing, maybe a bad thing, depending on where you're sat, whether you're the claimant or the respondent. The big decision when it came, or the big consideration when it comes to time, in my experience, is really the panelists that you choose. If you are using a three-party or a three-member panel, and each of you are looking to get senior, busy lawyers, they look at their calendars and look at their diaries, and it may be 2-3 years into the future before they can hold up a 2-3 week hearing. And that's really the decision that's taken, and then the timetable will be factored backwards. So timing-wise, on the whole, it's quicker, but it can equally be just as long as a litigation. So the question kind of when it comes, and I was asked to look at best practices, is then when would you use an international arbitration? Everyone can read, I'm not going to go through all of them, but the big one in my experience is when there is a highly complicated dispute. I would certainly, from a Middle East perspective, be looking to go to arbitration over a local litigation. And the main reason for that, and when I say that, I'm talking really the construction industry, the technology, the IPR side of things. And that's really because I would want some element of control over the selection of experts. There's a limitation of that control because both sides will be choosing them, but at least you have one person who is presenting that expert testimony in court that you at least have had the control of selecting. If it's done properly, they're fully independent and that control is limited, but you at least know where the voice is coming from and you have a certainty over what he's going to be saying or she's going to be saying. I've had some situations, and I hope I don't get in trouble from any locals here, the court-appointed expert system in the Middle East, and not just the UAE, I've had it in Qatar and other such jurisdictions. Sometimes I really question whether they can qualify as an expert in a specialist niche area. They are very competent technical engineers, but on specific issues, if it's a delay case, they don't really have any delay analysis perspective, and therefore that expert process in the local litigation doesn't actually fulfill what I feel is required. The other real big thing from a Middle East perspective, and there are some other comments, as I say, from a time perspective, I won't go through them all, is the confidentiality of an arbitration compared to the publicity that can come through a litigation often assists with an ongoing relationship. And relationships are everything in business and even more so in the Middle East. But an arbitration tends to be less confrontational. It seems to be less almost argumentative. And it means that coming out the other side of it, you can carry on an ongoing business relationship that if you had gone through the court system doesn't necessarily remain. The other best practice from an in-house perspective, and this is something very easy to stand up here and say to a room like this, very difficult to say to a group of salesmen, is when you're actually closing the contract at the sell stage, is disputes resolution clauses really do matter. In my experience, it's very rare that you will get to have a dispute and then be talking about how you're going to resolve it. It's normally a contractual mechanism, it's defined in the contract. It's very difficult from an in-house lawyer perspective when you're doing that review to let the agreement be signed off by management to then create a big issue around dispute resolution clauses because it doesn't bode well with the other side. However, it really is as important as every other mechanism, limitations, liability, etc. Because the choice of law and the choice of seat can have such a fundamental impact on the dispute when it actually gets through that. And there seems, in my experience, to be a movement towards a multi-layered dispute resolution clause where it starts with escalations to management and then starting with mediation or adjudication, ending up in arbitration and then, God forbid, going into the local systems. In my experience, look great, makes everyone feel happy. In practice, they simply don't work. And absolutely fantastic if you're the client and you're wanting to delay the dispute process and play for time. But really, this staggered approach doesn't work in practice. So for me, the best practice, and trying to always tie back to this, is look to choose a seat that is in a mature, independent jurisdiction. And I won't go any further than saying that here. And limit the time period of this dispute resolution process. You don't want to be stuck for almost 2 years, and if there aren't time limits and you're going through escalations of management levels, you can be in a situation, it's 2 years after the dispute started before you can really get anywhere going. And the longer it takes, the more likely you have witnesses or just knowledge or records that go missing, which doesn't help anybody. The other best practice, which I think is a relatively new development, is the use of IT tribunal software, and this is litigation software as well. And I guess I should caveat, I don't work for any of these firms, so this isn't a sales pitch. But the use of things like Opus Magnum, in my experience, have been fantastic. When the bundles are really heavy and huge, having that IT-led solution does make the whole process run a lot smoother. And the real question is the cost. And there's an immediate cost that you have to pay to set it up, but I believe when you then factor that in with the actual time that's taken from the legal team managing everything and the hearing time when it gets to bundles and referring to, they do pay for themselves. So although immediately when you kind of start up and you're trying to delay the cost spending in any form of dispute, use of an IT platform at a very early stage, in my experience, really does fund itself. And if anyone is here from Magnum or anyone else, you can give me the bribe afterwards. The other challenges then are moving on to best practices. Big challenge for myself in the arbitrations I've done here is the limited disclosure. Now, as much as that's a challenge, depending on where you are and which party you are and the fact of the case, it may also be a benefit because you may have some documents you simply don't want to be disclosed. And there is across every, and this isn't just an ICC or a Swiss, this tends to be the standard process in all international arbitrations. The tribunal panels are not invested in the case yet. This is a very early stage in the process. They are making decisions really on de facto arguments. Some of those arguments may not even be, God forbid saying it, the most truthful from any parties. They're making statements and the tribunal are making decisions without going into the real detailed merits. So really you have to know your arguments and know the evidence that you're relying on, whether you're the defendant or the claimant, from the very outset. And you need to know how much control you have over those documents, because international arbitrations can go through the whole way without you ever receiving those documents that you know exist but aren't in your possession. The one thing I will say, though, is it can be a benefit. I've had cases, particularly against some governments, where it's very clear that evidence exists, very clear that it's relevant, and it isn't disclosed in that process. Depending on the institutional rules, you can, to a greater or lesser extent, have huge adverse inferences that you can argue towards. And I've had situations where those adverse inferences are, in our opinion, better than what we think we would have got if the documents had been disclosed. So, although it's a challenge, depending on the details, it can also be a huge advantage. So you need to know your end game of the case and where you want to go, because this disclosure process comes down to a decision very early on in the process. it's not appealable, and it really could swing some fundamentals of the case. The other major challenge that I see from an international arbitration is the same street rules just don't apply for both parties. Institutions have rules, courts have rules, and you go into the litigations and things, but there is a huge range of cross-cultural differences. So the most obvious that I've come across is when it comes to accusations of wrongdoing, whether dishonesty or anything else. For myself, being called to the English bar, we have a very high standard that has to be crossed before you can start claiming dishonesty in an arbitration or court setting. Respectfully to other jurisdictions, I haven't seen that in other jurisdictions in the Middle East, and very often there are accusations that are alleged very quickly from one side, and I've been in a situation where I've kind of almost been kicking under the table to try and react to those, and the QCs or the senior lawyers that we've instructed are not comfortable in using the same weight of argument. And depending on who is on the panel, depends on how much they're going to be swayed. There's also a big implication that I've seen in regard to fundamental causation, in that although that should be universal and not binding on any jurisdiction, certain jurisdictions, in my experience, really miss correlation and causation and mix it together. So we've been in there and arguing a certain causation link, and this therefore means that. The other side of the room, which I haven't experienced when they're in the same kind of jurisdiction or same culture, really see that A plus B equals something very different to C. And that's a real challenge, that there really is nothing you can get away. That's just an international litigation situation. But the difference between the arbitration and the litigation is you may have different cultures then on the bench as well. So you've really got to be mindful of those cultural and jurisdictional differences. And the only other one I will touch on from the talk is the relationship with experts is also very different in my experience in international arbitrations. There's those who really consider the independence of the expert to be sacrosanct and paramount, and there's those who really see experts as hired guns and almost claim builders. And that's something in the more international sphere I see relevant more than any other thing. And I will come on to that now when I talk about spurious claims, because partisan experts really do exist, and I see them far more in the Middle East setting, not necessarily Middle East experts, but people coming over and being far more happy in that role to be a claim builder, if you like, and put forward their party's case, notwithstanding that the rules of independence are paramount. And there are limited means to get these type of reports and this type of evidence struck out at an early stage. Tribunals seem to be very reluctant to make a decision of banning any form of evidence until they've heard it in its entirety. So there may be a very spurious claim based on very questionable expert evidence that you think you can really discredit very easily, but you have limited ability to get that removed from the case. From a best practice perspective, in my experience, they're just an unavoidable reality. I mean, there will be spurious claimants and even spurious defendants all over the place, and not necessarily just an arbitration issue. You've really got to use cost protection offers as best you can to try and build pressure. And if you have a spurious claim, the strength of your defence is paramount to make them try and spend money. Because at the end of the day, in my experience, the spurious claims are paperwork that's been landed and requests for arbitration, and even detailed claim submissions of arbitration, where clearly they've done no more than take the claim document from the contract and headed and footed it in an arbitration document, and they've spent no further funds. If you force the issue from a defence perspective and put forward proper, detailed expert reports, correct witness statements, they should then, and I'm using the word should, have to spend some cash. However, it's not unusual, and I know some people are laughing. I've had situations where you get to the final hearing and they still really haven't put their hand in their pocket, and while it all falls apart for them at the hearing, that's 2-3 years down the line, and you may be looking at a legal bill of $5, $6, $7 million to have got to that point. And that's where the cost protection offers really come into value. And I thankfully have had some cases where we've put offers in early and really recovered almost 90% of our entire legal spend on the matter. The final challenge that I want to touch on, and is really almost an introduction to Mohammed when he comes in, because I think he's far stronger to talk about this. Sorry if you're not going to, but is the changes in the UAE and the latest amendments that have happened to the law. So there is now a possibility of criminal sanctions being raised against arbitrators and, as important, experts within the UAE. It's a new development. It happened just before Christmas, and it's currently being lobbied to be repealed and everything else. So whether it stays to be the law is really unknown right now. But it has immediately, as I've experienced it, brought a reluctance of the experts. I haven't had a situation where arbitrators have been concerned by it yet, but I have had a situation where a number of experts that are almost my go-to are really saying, look, I'm not, until I know where this is going and what my liability is, I don't want to get involved in this matter. So it is a challenge right now from an international arbitration perspective, where we're looking to hold it in the UAE. It's a new development, and really time will tell where it goes. And I think we're talking a number of years until we really know where it's going. But I would expect, and I haven't had this yet, but I would expect to have an increase in correspondence from lawyers threatening all kinds of this in pleadings about non-impartiality or non-neutrality, and can see that becoming a matter of course from a letter perspective. I don't know if you've already wrote the letters. Whether that has any impact on the people and whether that has an impact on the process, time will tell. But it's certainly a challenge of getting experts that otherwise I would have got involved in cases, making them kind of want to really open themselves up to that type of liability, particularly in a region where, as I said earlier, sometimes allegations of dishonesty are thrown around more readily than they would in other jurisdictions. So the final topic I want to just touch on, and this is really to open up for questions later on, is there's two different ways international arbitrations can be run from a process perspective, whether it's pleadings or memorials. Whether it's pleading or memorials, it really comes down to whether it's a civil or common law panelists. And there are pros and cons for each. In my experience, the memorial process actually tends to cost more money. It's the theory is that you get all the information out up front, but it does tend to mean that there are two lots of witness statements, two lots of expert reports, and cost more money. So we need to be very mindful when you're going into it, even at that early stage, where this is going to run, who's likely to be ruling, if it's common law, civil law panelists of what they're wanting to do. So thank you very much.